Good afternoon, everybody. Welcome back to another employment law Q&A session. My name is Chris Justice. I'm an employment lawyer, of course, with Samfiru Tumarkin, and I'm here today to answer as many questions as always that I can answer within the time allotted. So get your questions in. We'll answer them live, whether it's to do with a contract maybe you're wondering about, maybe you're going through some sort of situation in your workplace and you're looking for some questions or some answers to some questions there. Get your questions in for sure. And I'll, as I say, I'll do my best to answer as many as I can. I usually start, as always, with a few or at least a couple topics just while we wait for the questions to get in. This time around, I wanted to address a couple things that had sort of been in the news of late. One thing had to do with more layoffs happening across a lot of different sectors. In particular, ones that seems to be hit a lot in recent times has been the tech sector. Anyone in technology. There are a lot of people, as I say, getting laid off. In some cases, people are being told that they're being laid off on a temporary basis and that the company is looking to call them back as soon as possible. And other people are being laid off on a permanent basis, or in other words, essentially being terminated. So I thought I'd just quickly touch base on both those things. First is the temporary layoff. So if you are being told that you're going on a temporary layoff for some maybe undetermined amount of time, and that your company is looking to try to call you back as soon as possible, and you're wondering maybe what your options are in a case like that. First of all, in most cases, employers are not going to have the right to place you on a temporary layoff, even if it is for business-related reasons, even if there's no suspicion of there being any bad faith or potential discrimination. Employers do not have a freestanding right to place somebody on a temporary layoff. So that's the first and foremost thing. Need to understand that they don't have this right. There are some instances where they can essentially create this right. One would be having you sign a contract that allows them to place you on a temporary layoff. So you want to be mindful of that. If you're looking to be signing a contract, you're being asked to review something, you want to see if there's anything in there that mentions layoffs, something usually along the lines of the company reserves the right to place you on a temporary layoff for as long as permitted at law. So if you've got something like that in a contract of yours, there may be some issues there in your ability to push back against a layoff, but that's one instance. The only other general instance is where you've otherwise accepted the layoff. So if you've been put on a temporary layoff and you've agreed to it, maybe you've signed a document that says you acknowledge and understand and accept the layoff, that's going to be another situation where the employer is going to be able to lay you off for at least a certain period of time. In Ontario, employers can lay you off for either up to 13 weeks or 35 weeks where they have the right to do so. So it can be quite a while if you are called back, if ever. But yeah, those are the two instances where you'll be seen as agreeing or accepting the layoff. If it's in a contract or you've otherwise accepted it. Sometimes if you've had layoffs in the past as well, if there's some sort of a history to you being put on a layoff, maybe it's a certain position where layoffs happen each and every year, then that will be the other instance that companies can generally put you on a temporary layoff. But if it's not in one of these categories, they don't have the right. And if you've been presented with some kind of a layoff letter and maybe you don't want to wait for them to call you back if they are, and you want to go after your full severance, you can treat that layoff like a termination. You don't have to just wait around in hopes that you get called back. Generally speaking, again, at law, even a temporary layoff is going to be considered a termination. So that's with respect to some of the news, again, going out there about temporary layoffs, a lot of industries being hit. Of course, if you're permanently laid off and it's therefore a termination, you could be looking at upwards of 2 years of severance, depending on who you are. Courts are going to be looking at things like your age, the length of time you were at the company, the position you held at the time that you were let go, including what sort of income or compensation came with that, and as well just the general availability of other employment opportunities. So as I say, upwards of 2 years severance. And even if you're a short-term service employee, maybe you've been at a company for just a number of weeks or even months, you could still get potentially months of severance. So don't also assume that if you're on the shorter end of that sort of tenure, that you're not going to be really owed much severance, if any. Depending on who you are, there could be tens of thousands, if not more, potentially on the table there. So I'll get into some of the other topics I was going to touch on from the outset, but I do want to get into some of the questions first, just so we can answer them all. I've got one question in from Luna on Facebook, who's saying that they were assaulted at work by a coworker. They reported this to the management as well as the police, and the employer has not removed this person or made any changes, and I'm still forced to work with them. I feel very uncomfortable and anxious. Is there anything I can do? Yeah, absolutely. So number one, if you're assaulted at work, definitely you should be reporting it. If you don't report it, and God forbid it sort of goes unchecked, or maybe people don't even know what happened, or it's a he said, she said, you always got to contend with that. So definitely reporting it is good. Depending on the nature of the allegation, I would definitely recommend reporting it to management. And then again, depending on the nature, the police as well. So it seems like everything there was done correctly. I don't know if there's anything in writing that you may have sent to management about the assault, or about feeling uncomfortable, anxious to work with this individual. But I always recommend that people create a paper trail. So whether it's a complaint about harassment, obviously a complaint about assault, and as well, if there's any lingering complaints afterwards, where you can't work with somebody, you don't feel comfortable, you feel anxious, you want to generally try to communicate that in writing so that there is that evidence of you saying as much to your employer. So again, you don't get back into that he said, she said battle. And as long as your employer knows you've got the evidence, then in this particular situation, they should be doing everything they can to accommodate your request. Whether or not they remove the person, that's a possibility. But at the very least, in terms of accommodation, making it so that you don't have to work with that person, so that you don't have to interact with that person. Maybe report to another manager if it's your manager, or if it's just a colleague of yours, maybe in a similar position. As I say, the request being to work in a way in which you can avoid interacting with this individual. Especially if the police lay charges, or there's some acknowledgement that an assault happened, or essentially if it's an open and shut case, it would be quite unfathomable for the employer not to try to accommodate that situation. And if they don't, or if you feel like they do, but they don't really do it so seriously, and maybe they just try to accommodate so it shows on the face of it that they did something, but they've really not done as much as they could, then your employer is going to be liable for possible violations of occupational health and safety. Your employer is going to be liable for having to likely pay you your full severance if you can't or don't ever go back. And as well, potential discrimination angle. So yeah, I think your employer would have a lot to lose by not addressing the situation very seriously and very promptly. So ideally, they make the changes that need to be made for you to feel comfortable. Hopefully other things happen, maybe in terms of the police, but at least as far as the employer is concerned, they got to ensure a free and safe, sort of healthy work environment. And again, if they don't, there's a big can of worms there that gets opened, and you would have a lot of options as far as, going after them for a number of different sets of damages. You say you're still forced to work with them, so it does seem like they've failed in that regard to do what they need to do, and maybe they're hoping that you quit. But yeah, it seems like there's a lot of bad faith there. I would recommend you or anyone in the situation give us a call, because there's at least 3 or 4 different ways in which this particular employer could be liable to pay you compensation, and you won't be forced to have to keep going into that work environment for an indefinite period of time. I've got another question in from RTL on YouTube, who's asking whether an employer can force you to use your own credit card to cover company expenses. So technically, there could be a number of different arrangements, but at the end of the day, if you're paying personally for company expenses on your own card, there should be some expense form procedure, perhaps, where you would be able to list the expenses, maybe couple that with receipts or just verification that you did incur that cost on your card. And because it's a company related expense, I would imagine that that's something that's going to be covered. I don't know if there's any particular employment agreement or something you may have signed that talks about company expenses, or I guess expenses in general. Sometimes there are scenarios, even if they're more limited, where individuals might be on the hook to cover their own expenses. But for the most part, if you're an employee of a company, I would expect there to be an expense policy. And of course, there shouldn't be any reason, generally speaking, for you to have to be incurring personal costs for those expenses. So I would submit them, provide the evidence or the backup, the support. And if the employer still refuses to cover those expenses, maybe point them to the employment agreement you may have signed that talks about expenses being paid, or and maybe in any event, give us a call, because if there are a lot of expenses there, not only could you be entitled to your expenses being paid, but if your employer is liable to pay you for those expenses, by not doing so, you could argue they've breached the employment agreement that you had with them, whether it's in writing or not. And that could then lead to other options for you, as far as possibly leaving that situation, going after the company for full severance based on this breach of the understanding or of the agreement. And if it's a particularly big expense, then even more, I think, ammunition for you to potentially go down that path. So don't feel like also that you're stuck in a situation that you got to keep working, and that if you leave, you're going to be left with nothing. Give us a call. There may be some options, like I say, for you to leave and treat the situation as though you've been let go. And hopefully on top of that as well, cover those expenses. Got another question in from Ilona, who's asking, what happens if you're on a temporary layoff past the allowable time? Is an employer allowed to extend your layoff period? So sometimes when a temporary layoff happens, and let's say you've agreed to it, or there's a contract that sets out what the permitted time is, and then they happen to go beyond whatever you've agreed to, or, again, whatever's in your contract, whatever the permitted time is, again, might be 13 weeks, might be 35 weeks. But it could also be something anywhere in between there if there's a different agreement going on. But if they pass that time, then technically all you did was consent to a layoff for that certain time frame. So when that time frame goes beyond it, you could argue that there's no longer consent. So that's one angle you could go down, to say, I didn't agree to it to this extent, and you don't have my consent, so therefore I'm treating my employment as being terminated. But also, if just by the legislation, if you look at the legislation and you say 13 weeks or 35 weeks, if they go past those specific timeframes, depending on the situation, that will automatically turn into a termination at law. And then you can go after your full severance rights. So sometimes they'll tell you, yeah, our intention is to call you back within 13 weeks or 35 weeks, and they don't. Even if they try calling you back later at those timeframes, it'll automatically trigger a termination for which you'd be owed your full severance. So yeah, there definitely are certain issues when companies go past the allowable time, and you'll want to be aware of that. I've got another one in from Beguiling on YouTube, who's saying that their partner was let go because they filled out an incident report incorrectly. Can they do this? Shouldn't they offer training or something to help? He was there for 10 years and there was no issue before this. Yeah, that does seem like a relatively minor thing to let somebody go for, especially given the years of service and the, I guess, the spotless record beforehand. I'm not sure if this particular incident report or the improper filing or filling out of this incident report was especially serious or sticks out in the company's mind for whatever reason. But assuming it did, or even assuming it didn't, people can essentially be let go for any reason the company wants. So you don't even have to have made a mistake to be let go. You could literally be the best employee in the world for 50 years, 10 years, 20 years, doesn't matter. And your employer can still technically come to you on a random Tuesday and say, sorry, today's your last day. No notice, you're done today, pack up your stuff. As long as they give you a fair severance package, whether it's by giving you notice and some pay, or maybe no notice, but just a bigger pay, then the courts and the law is generally going to allow that to happen. They don't take issue with that. And so while it may seem trivial for someone to be let go because of maybe filling out an incident report in the incorrect way, and while it may make sense that they should be offered training and that this is something that could be corrected going forward, so why even jump to the termination, it still doesn't mean that the company that can't do it or won't do it. All you can really do at that point after you've been let go, assuming, of course, you're not being let go for discriminatory reasons, because that's the one main caveat in terms of reasons for why people are let go. As long as it's not for something like that, then it can be literally for any reason, even if you're a perfect employee, as frustrating as that may be. But you still want to make sure that you get a fair severance package. And that's usually where, in a lot of cases, companies get tripped up, is they'll let somebody go, say that it's not working out, or we're going in different directions, whatever statement they generally come out with. And then they'll only give somebody maybe a fifth of what they're really entitled to, or just a fraction of what they're entitled to. And that's where the issue comes in. So unless there's some evidence, some clear evidence that would show discrimination or extreme bad faith in the reasoning for being let go, that's unfortunately just the way things work. And you at least want to make sure, again, that you're getting your full severance, though, having said that. And 10 years in, someone with 10 years service could get 12, 14, 16 months of severance. So you want to make sure that you're getting the fair package. And you probably want to give us a call as well, just to make sure, because I doubt in the first instance anyways, after being let go, they're going to be giving someone with that amount of service close to what's fair. Another question in from Jedi on YouTube, who's asking, if my coworkers are filing false harassment complaints against me, is there anything I can do? They're claiming normal actions and duties I'm performing are malicious intent when they aren't. Yeah, so unfortunately, when you are being faced with a complaint against yourself, you'll definitely want to get as much info and details as you can around the complaints, the basis for the complaints, any evidence relating to the complaints, because you're going to want to provide a fulsome answer in response to those complaints. And depending on what the complaints are, I mean, there are certainly situations where someone can just completely make up a complaint and abuse the harassment complaint system. And if it gets to that level and it's really that bad, then those people can potentially be penalized for just abusing the system, bringing forward a meritless complaint. If there's some merit to the complaint, doesn't have to be a ton, but just some that warrants investigating, the courts and the law in general are going to allow companies to investigate these things. And for the most part, you just want to make sure that you provide a response that absolves you from any blame. You would want to look at the definition of harassment, understand kind of what the complaints are. And then, if it's not true, or there's no merit, there's no malice in what you're doing, you definitely want to put that in writing on the record. And if the investigation comes back, saying that those complaints weren't justified, or they weren't made out, or they weren't valid, then usually that's the most of indication you can hope for. If it gets to a point where it's bordering on abuse and you're having to go forward with multiple complaints all the time and they just keep getting shut out each and every time, I would start pressing for more action to be done against those individuals. But usually the most thing you can hope for is responding, getting vindication through those complaints going away. And look, if you feel like you're on the end of the harassment, you're being harassed, not to say you do this in retaliation, but you may want to consider filing a harassment complaint against these individuals. But yeah, I definitely think there's a point in time where it could get too much, where you'd say, I'm tired of defending these meritless complaints. Say 2, 3, 4 of them have happened and they're all just sort of completely dismissed. There may be a situation there where it's untenable for you to work, and you may be able to get out with some recourse, some options. But I think for now, all you need to make sure is you understand the complaint, you respond appropriately, and then hope that the result goes in your favor. And if they uphold those complaints of harassment when you know they're wrong, that could also give you grounds for an action against the company. So it also could depend on what the response to those complaints is from the company as well. If they back them up or dismiss them. And like I say, that could actually give you some more options as far as leaving the situation altogether or putting some more liability on the company side if they're not doing a proper investigation. I got another one in, a question from Archie, who's asking whether an employer can force you to work a full notice period of 4 weeks. After 1 week, I said this isn't for me, but they say I have to stay for 4 weeks. So yeah, if you are let go, let's say January 1st, and you're told that, or sorry, let's back up. If you're given notice that you're going to be let go on January 1st and your last day is, let's say, February 1st, depending on what's in your contract, typically you would have to work out that notice period to get those wages. If your employer gives you a working notice period of, say, 4 weeks, and you just don't want to work there for 4 weeks and you want to only do, say, 1 or 2 or 3 of those weeks and you want to leave after that, that could be bad in the sense that you could be seen as basically quitting your job before the end of your employment. And you wouldn't necessarily have an option to go after the company for more severance beyond that. Because the one thing I was going to say is that if all you're being given is 4 weeks of notice, you might actually be owed more than that, or at least more severance in general. And so I wouldn't say necessarily just to accept even a working notice period of 4 weeks. But if you're going to leave before that, it could be an issue for you in terms of having any ability to get money beyond that point. You would have to show that things are so toxic that no one in their right mind, reasonably speaking, would stick around. And that would require you to have to provide all the details about how it's toxic. For instance, maybe you're being harassed on a daily basis. Maybe you've been assaulted. There could be a whole slew of things that are going on. But there could also be a number of things that are toxic that wouldn't give you the same leverage that other examples of toxicity would. So it really comes down to how is the workplace toxic? That's going to determine whether you're justified in leaving early. But if it's not toxic enough and you still want to go, you might be able to leave, but you won't necessarily have any right to pay after that. But I would say give us a call, Archie. I think there's a lot going on in your case. And before having any major communications back and forth, I'd say give us a call just so we fully understand the situation before you're out of there. And just so we understand how much you might be entitled before you leave and maybe walk away from money that it was otherwise going to be on the table. Got another question in from Peter, who's saying that their work hours were changed from 7:30 to 4 to now 8 to 4:30. So a change there for sure. Their busy season starts next month, and management asked everyone to step up and work 12 to 8. And if no one steps up, they will pick people pick people's work to whenever the hours they want. How can this even happen with obligations and such to have your schedule change whenever they desire? Yeah, so you before you can argue that a company can't change your schedule around at any time it wants, you have to first establish that you had a set schedule. So if you can, and this is just generally speaking, if you can show that maybe in a contract or just by virtue of working there, that you worked consistently the same hours, then if enough time passes of you working those hours, then it's reasonable for you to develop an expectation that those hours will continue to remain the same. So let's say I work 9 to 5 for 2 years. I'm expecting in my third year to work 9 to 5. If I work 9 to 5 for 2 months, maybe I can't have that same expectation. But if it's in the several months or years category and things have been consistently the same throughout my entire time there, then yes, I think you have grounds to say that your expectations are such and that any significant change is not something you signed up to do. I think normally if you go from 7:30 to 4 or 8 to 4:30, and now it's going to switch to 12 to 8, that's a pretty dramatic shift change. It might be similar hours in general, but now you're having to consider working past 4 or 4:30 into the evenings and, starting your day much later. So I would say that the change could definitely be argued as a significant one, as long as you can first show that you have a reasonable expectation to the previous hours, that you've always worked those hours, that's never changed, maybe over the course of months or years. and now this big change is coming in. Because if that's the case, then it's likely that you're going to have the option to say, no, I don't agree to this change. It's not what I signed up to do. I haven't signed anything saying you can make these changes. I've never agreed to this. And if you're telling me that it's either this new way or the highway, then that could potentially trigger your rights to get your full severance. That might be known as what's called a constructive dismissal. And you may at that point be able to actually leave, although it would be more of a forced resignation, but you might have the ability to leave and go after that company for your full severance based on the breach of the terms of your employment by virtue of the schedule change. Before you say, though, anything about I'm leaving, I'm quitting, this is why, I would definitely give us a shout. Because, yeah, you want to show on the record that you give the chance for them to change their mind as well. Maybe tell them that you're ready, willing, and able to do your current shift as you've always have, but you're not agreeable to this new shift. Put that in writing typically, see what they come back with. But yeah, generally good to get some legal advice just so that you're not saying anything that might come back to haunt you later on. But from the face of it, it does seem like there's a potential constructive dismissal here. So if that's not what you want to do ultimately, and you're just going to be leaving anyways, then I think it makes even more sense to get in touch with us and try to figure out what your severance rights are, and then, potentially go after tens of thousands of dollars there. I've got another question in from Yusuf, who's asking, why can't a lawyer take cases when they have a union? It doesn't help from union. What should I do? So yeah, in our firm's instance, for example, we don't take unionized work, I should say, because you actually, as a unionized member, need to go through the union process, the grievance process first, fully exhaust that process before you can stand any chance of having a lawyer such as myself take on your case. Usually when I take on cases, I'll try to settle without a lawsuit, but sometimes you can't get a settlement that way. You have to sue companies. But unfortunately, you're not able to even sue the company if you're unionized and you haven't gone through the full union process. So normally you would submit a grievance, obviously talk to your union rep, go through the grievance process. And depending on what the outcome of the grievance is, you could get severance, you could get your job back. There's a whole number of remedies that are available. If the grievance process doesn't end in the way that you want, there might be a way for you to appeal the decision. And if you don't think your union's representing you in the way that you want, my understanding is you have to file a duty of fair representation claim against the union. And you need to argue that the union has not advocated essentially in your best interests. And so if you've used the whole grievance process and you file the duty of fair representation claim against the union and win, then there's a possibility you could get a lawyer such as myself or someone at our firm to represent you, even though you were unionized at some stage. But unfortunately, when unions are involved, the collective bargaining agreement is what sets the dispute resolution process. So I actually can't get involved. I would be prevented from being able to go forward with a case like that until you've exhausted all those things. Unfortunately, unions don't always do the best of jobs, but that's where you need to file your duty of fair representation claim. And depending on the results of that claim, if you're successful, there may be some other avenues available to you, and a lawyer such as myself might be able to represent you. But until that happens, unfortunately, I can't. And in general, our firm specializes in non-unionized employment disputes. So definitely, if you're someone in a non-unionized context, give us a shout. That's going to do it for my time today, actually. So for those of you who I didn't get around to answering the questions, we do this stuff every single day, or almost every single day, it seems like. We've got another one going on Wednesday, September 11th. You see down there below with Lior. So any questions not answered, get them in with Lior just 2 days from now. And otherwise, I'm sure I'll be back at some point. But thanks again for everyone joining today. Thanks to all of you who got your questions in. Appreciate it. And I'll definitely see you all soon enough. Do take care otherwise. Have a great day. Bye for now.